Okay, we're going line. We're going to talk about we're going to talk about covenants, not chapter 11. Maybe it is within chapter 11. Covenants, promises, running with the land. There's two approaches to look at this. Traditional approach and the unified restatement approach, which is still valid in many jurisdictions. Under the traditional approach, covenants enforceable by law are called real covenants. Whereas, actually, if I'm going to say whereas, so within this section, the origin for the doctrinal basis is contract law, because no new negative easement types. So the origin is from contract law because once upon a time, England stopped naming and making types of negative easements. So that's where your real covenant originated. It's applicable to subsequent purchasers, successors, and interest. Spencer's case allows negative easements to apply to subsequent purchasers through horizontal and vertical privity. So the requirements here is an agreement must be in writing. The parties must intend to bind future successors. The promise must touch and concern the land. And there was privity of estate between the covenanting parties. Privity of estate in England applies to leasehold only. Privity of estate in the U.S. is not so limited. Covenants enforceable. Equitable servitudes. Case Tulk versus Moxhay founded equitable servitudes enforceable by injunction, enforceable against success or owners with intent, touch and concern, notice, and there was no requirement for vertical privity as is required in American Law of Property, Section 9.31. Remedy is blurred under the uniform treatment. The remedy determines the treatment. So for a breach for damages, that would be a real covenants treatment. However, if you are seeking an injunction, that would make the subject of the lawsuit a equitable servitude rather than a real covenant. Blurred, unified treatment under restatement, and enforcement of a lien have equals equitable proceeding. So Powell on real property discusses equitable servitudes being used to enforce an equity as a promise now turned into interest in land. An equitable servitude is not a real covenant, which is an estate in land. An equitable servitude burdens the land. An equitable servitude has a no privity requirement. The original promisor and promisee are immune in law and equity, and the promisee may no longer benefit or bring an action for benefit after conveyance. Another case is the deposit property versus immigrant, which defines touch and concern to justify a homeowners association fee as a covenant that runs with the land. The case notes that I have here is that for the first time that a homeowners association was tried, treatment was a real covenant because remedy of monetary damages sought, even though enforcement of lien is an equity proceeding, as we said only a moment ago. Touch and concern test arose from this case. Development covenants might be a term used for this type of case. Benefits and gross - homeowners association can enforce as a third party beneficiary. Defeasible fees as land use source. Restatement third approach. Equitable servitudes and real covenants run with the land. And no more touch and concern. No more vertical privity required. Differences between negative and affirmative. Negative are easements. Affirmative, the owner is entitled to enforcement of the covenant. Enforcement of in gross is only against a legit interest. Example Wilcox, example Evans, scheme dash general plan, restatement thirds of property hold zoning is not universal throughout the subdivision. Subdivision map restrictions run with the land. In Massachusetts, neighbors, beneficiaries of restriction in subdivision map. In Virginia, there's no real difference between a real covenant and equitable servitudes, except no general plan covenants will be enforced as an equitable servitude, for example, by injunction, unless horizontal privity is present. Implied reciprocal servitude theory. This gets tested a little bit. So the rest of this is kind of tested, but only to as part of testing a more basic issue or more central issue. And so the implied reciprocal servitude theory is a bit different. According to this theory, when a common grantor later sells a parcel from his remaining land, the prior purchaser is enforcing a reciprocal servitude that is implied from a common plan of development. The restatement third property offers a third-party beneficiary theory. Sublease assignment express restrictions in the deed was for the benefit of all of the residents of the development, and equity is merely permitting beneficiary to enforce it as a third party. Some cases here, Sanborn versus McLean applies a reciprocal negative easement to prevent land uses contrary to the PUD, which is the planned unit development, that may not have been expressed. In the Shelley versus Kramer case, ensures that discriminatory covenants cannot be enforced. Case involves a racially discriminatory covenant that was upheld in the court of law to constitute judicial and state action, so that on appeal, the covenant becomes subject to the 14th Amendment Equal Protection Clause and therefore is an unenforceable covenant, or that would make covenants of discriminatory covenants unenforceable by a court. Land use controls, the law of servitudes, real covenant dash promise concerning use of land that runs. So a real covenant is a promise concerning the use of land that runs with the land at law as opposed to equity and estate. It's enforceable by successor owners of promisors who are benefited land against the promisor or successor owners of promisors' burdened land. Categorically, a real covenant is always an equitable servitude, but an equitable servitude is not always a real covenant. History and problems. Adjoining landowners often wanted to enter into an agreement to restrict use of land. For example, A, owner of Blackacre, and B, owner of Whiteacre, agreed that A would not build a piggery on Blackacre. A and B each agreed that they would not use their respective parcels for other than residential purposes. And so as long as A and B own the land, agreement could be enforced as a contract. But assume A conveys his land to C. At common law, B could not enforce the contract against C because courts did not recognize assignments of burdens. Now assume A still owns the land, but B conveys to D. In common law, D could not enforce the contract against A because common law did not recognize assignment of benefits. And if A conveyed to C and B conveyed to D, then D could not enforce the agreement against C. The problem was that English courts refused to allow contracts to be enforced by subsequent successors in interest. So, creation. Since a real covenant is an interest in land, it must be created by a writing signed by the parties to be charged. If a grantee accepts a deed containing a real covenant binding on the grantee, she is bound by those covenants, even if she does not sign the deed, as indeed grantees usually don't. And the analysis is the first determine whether the benefit must run or a burden must run or both. Situation 1, A promises B that A will only use his land for residential purposes. A promisor, has the burden of the promise. B, the promisee, has the benefit. Now A conveys to C. B still has the benefit. C now has the burden. For C, 2, ... And then there's another 2 situations here that I've written out, just like the one I just read. I don't think it's necessary that I read it because it's not. Actually, remember these are class notes that I typed. I retyped. So let's just move on to the privity of estate. Horizontal refers to the relationship between the original promisor and the original promisee. So the A and the B, and it must be a grantor-grantee relationship. The promise must be indeed conveying land. A owns Blackacre and Whiteacre. A conveys Whiteacre to B. A promises indeed that A will only use Blackacre for residential purposes, or B promises in the deed that B will only use Whiteacre for residential purposes. So one thing that this implies is that the land had to all be under the same owner and like subdivided, but maybe I'm jumping to conclusions, but that's how that sounded. So because the promise must be in a deed conveying land A owns, and they own Blackacre and Whiteacre, and they conveyed Whiteacre to B. So I don't think that's really a requirement, but I think probably in some context it is. Privity of estate, vertical. So we just finished talking about privity of estate, horizontal. I think it's created whenever a grantor and a grantee relationship's created to allow their neighbor to do something on their land or not, or prevent the neighbor from doing something on their land. So I don't think it needs to all be under the same common ownership and then subdivided. Privity of estate, vertical, refers to a relationship between the original promisor, promisee, and successor in interest. It must be a voluntary transfer. Succession by AP, adverse possession, does not give privity of estate. Differs for running any burden by burden and benefit. So that's your vertical privity. It's only saying that it refers to a relationship between the original promisor, promisee, and successor in interest. It must be a voluntary transfer. Succession by adverse possession doesn't give this privity of estate, and it differs for running by burden and benefit. And here's kind of in the next list potentially those differences under privity of estate, vertical. For the burden, on the burden side of the list, and the benefit side of the list, what's the same and what's different, right? So attaches to estate and land is for the burden, but the benefit attaches to the land itself rather than to an estate and land. So that's the one different. Next line down, successor must succeed to same estate to be burdened, but for the benefit, the successor may succeed to any estate. So for the burden, it has to be the same estate, whereas the benefit could be any estate. Now, we're listing couple, fee simple, life estate, life estate. What they're saying is, for a burden to run, the successor of a fee simple must succeed to a holder of a fee simple. If it's a life estate, they must succeed to a holder with a life estate. Whereas the benefit, a successor could just succeed to a life estate from a party that has a fee simple. So it's not so limited. Now, next section is thus, and these are just examples. So I'm going to skip them. I don't want to make it too hard. But again, the burden attaches to the estate and land, and the benefit attaches to the land itself. So those are just your differences. It's a table of differences. 2 examples, skipping them. Equitable servitudes is the next section. So I think what we just went over was real covenants. And then for equitable servitude, this is a covenant that can be enforced in equity as an injunction, for example. It would not necessarily qualify as a real covenant at law. because there's no money damages available. So why is that? As a general rule, if an interest qualifies as a real covenant, it must also qualify as an equitable servitude. Analysis. Does it qualify as a real covenant? You do the same analysis with a real covenant. Does the burden run? Does the benefit run? And here in the equitable servitude table of differences between burden and benefit, for the burden, you need only an intent that the burden run, and privity of estate is not required. For the benefit, you need the intent that the benefit run, but privity of estate of a horizontal nature is not required, but of a vertical nature, there's a split in jurisdiction where the majority doesn't require vertical privity, but the minority rule requires that the holder of the benefit must succeed to some estate. Now, regarding touch and concern, a burden must involve a promise that touches and concerns the burdened land. For the benefit, the promise must touch and concern the benefited land. Notice is required for the burden. No notice is required for the benefit. And I'm going to skip the next section because I wrote question mark. I don't really know what it pertains to. I think it's a real covenant, and everything that I previously said is the same until you get to the privity section. So privity of estate of a horizontal nature between the original promisor and promisee seems like a requirement for the burden to run, although it's not a requirement for the benefit to run. Whereas, and I do think we're talking about real covenants here, vertical privity is required for the burden to run and for the benefit to run. And when you're talking vertical privity, you're talking between the original promisor and the successor in interest. I'd love an example of that. But what we get is, what is touch and concern? It's the same meaning for both real covenant and equitable servitude. It refers to the effect on use or value of burden benefited land and arose as a way for courts to end covenants and servitudes after the value surpassed. Negative covenants, restrictions on use of servient estate. Example, no factory, no piggery. Negative covenants always touches and concerns burdened estate. Restrictive use to those specified, even if only one is used. For example, a factory, forbidden, still restrictive use, and also makes the land less valuable. We have a lot more here before we get to condemnation. Change circumstances and condemnation. Before we get to zoning, we have like 5 more pages. So negative covenants usually touches and concerns benefited if property is close enough that the property is more valuable, or if too far, the courts may not recognize it as your equitable servitude. Example, covenant not to compete. A, owner of Blackacre promises not to build a grocery store on it. Negative covenant, since it restricts use of servient estate. Usually enforceable if reasonable in duration and area. Touch and concern for affirmative covenants. Promise to perform an act or allow someone else to perform an act. Example, A, owner of Blackacre promises that B, owner of Whiteacre, may draw water from A's well on Blackacre. Act to be performed on servient estate, for example, water from well, usually. Affirmative covenants. Act performed off of burden estate, for example, repair house on Whiteacre, will touch and concern the servient estate only if both benefits makes it more valuable and burdens that estate. Example, the Deposit case. Act performed off of burdened estate will touch and concern servient estate only if it both benefits, makes more valuable, and burdens the estate. Example, Blackacre is a common development, a housing development, a condo. A, owner of Blackacre promises to keep common areas in repair. Touch and concern Blackacre, but because by making common areas, road, sidewalks, clubhouse, attractive value of Blackacre is enhanced. A, owner of Blackacre promises to build a house on Whiteacre. Will touch and concern Whiteacre, but will not touch and concern Blackacre. Since there is only a burden, there's no benefit. Negative covenants running with the land, I think, unless it's just covenants running with the land. That just happens to be in my outline, letter N. Discriminatory covenants until the Fair Housing Act of 1968 and the Civil Rights Act actually of 1866 replaced in 1968. Court's declaration of money damages against a seller who violates discriminatory covenant constitutes an unconstitutional state action under the 14th Amendment, which is applicable to the states. Example, Burroughs versus Jackson from 1953. You're so cute. You're so soft and cute, that baby. All right, what's this section? 3601-through 31. The Act makes it unlawful to refuse to sell, rent, or otherwise make unavailable a dwelling to any person because of race, color, religion, sex, national origin, familial status, or handicap. That sounds like language from the Fair Housing Act. Of the few that I just listed, it's definitely Fair Housing Act language. At section 3604, the Fair Housing Act prohibits the printing or publishing of any statement indicating a racial, religious, or ethnic preference with respect to the buyer of a dwelling. Mayers versus Ridley, 1972, a deed with restrictive covenants violates 3604C. Group homes often challenge covenants calling for single-family residential use only. Are they single-family residences? Is architectural restriction per Blevins versus Barry Lawrence County Association for Regarded Citizens, Returned Citizens in Missouri of 1986. No function as a family independent of relation per Berger versus State, New Jersey, 1970. Yes, blood relation, marriage, and adoption per Slaver versus Hunter, Texas, 1981. Restatement third of property servitude, section 4.1 comment, report note of 2000, group homes not commercial. In Knudsen versus Trainer, group home is not commercial use, but not Hageman versus Worth. WA, group home is a commercial use. Constitutionality issue, Hill versus Community of Damien of Molokai from New Mexico, 1986. Termination of covenants. Merger on the basis of unity of ownership of the benefits and burden by the same person. A formal release, which is normally written and recorded. Acquiesce, which arrives when the plaintiff has failed to enforce the servitude against another or other breaches and then seeks to enforce the servitude against the defendant. Abandonment, which resembles acquiesce, except that it makes the servitude unenforceable as the entire parcel rather than only as to the plaintiff immediately involved. The equitable doctrine of unclean hands, according to which the court will refuse to enjoin a violation of a servitude that the plaintiff previously violated. The equitable doctrine of laches, which involves the unreasonable delay by the plaintiff to enforce the servitude against the defendant, causing prejudice to the defendant. Laches does not extinguish the servitude, but only bars enforcement. Estoppel, if the defendant has relied upon the plaintiff's conduct, making it inequitable to allow the plaintiff to enforce the servitude. And exercise of eminent domain, basis of prescription, changed conditions doctrine. So, citing a case, Western Land Co. versus Truskolaski defines changed conditions doctrine. Burden on moving party to approve restrictive land use covenants have outlived their objective purpose, been thwarted, and would be inequitable to enforce on owners, for example, of no or low value to owners. Covenants no longer suitable in light of changed circumstances. Money damages for breach of servitude. Injunction to enforce covenants equally applies to easements by lesser standards or restatement. Third, relative hardship doctrine. If enforcement of a covenant would cause a hardship to the servient owner without a greater benefit to the dominant owner, the court will not grant an injunction. That's the relative hardship doctrine. Covenant duration, usually intended by parties. Covenants last as long as intended by parties. For example, no general public policy on this. Perpetual, if a conservation can be perpetual by necessity, but can be limited, per City Brook 2 LLC versus Morton's Foods of Michigan, and invalid. Example, restriction possibly on alienation, though not declared. Condemnation, term of covenant by condemnation. Government condemnation of covenant requires compensation to the dominant owner. Holdout is enjoying multiple or single owners may defend a restrictive covenant by one owner seeking to reach restrictive covenant or override of probably the government condemnation of the covenant. I'm just saying, but I'm not sure if that's how that sentence ought to have been ended. But that's called a holdout. Common interest communities, according to the Uniform Common Ownership Act of 1982, there's a declaration of rules, disclosure to buyers, board governed, board elected by members to manage a property. There's a servitude regime, protects quiet enjoyment, common areas managed as a tenants in common, internal space owned in fee simple, commercial and residential use, apply for Fair Housing Act, financing, availability, rent control, and accounting for pro rata are probably some examples of what's covered under that act. Restatement third of property servitude, section 6.2, common A, engenders support levy money from members against their will if necessary, enforceable by fines and liens. Cooperatives are buildings owned by a corporation and owners own stock in corporation governed by elected board of directors. Residents have long-term renewable lease in the apartment. Tenants of the corporation. Social screening can't violate the Civil Rights Act because the tenants in common must cover defaults of other tenants in common to avoid foreclosure on corporate mortgage. And 2/3 share to dissolve the corporation. Example is Broom versus Biondi is an ethnic discrimination dispute if proven damages include admittance or money damages. Horizontal vertical privity is always met in a CIC, which I think we're talking about cooperatives. I don't know if CIC is the term for that. Might stand for something else. Almost done here. Pageant concern, usually an indisputed element. Case Navarstead versus Lakeside Village Condo Association of 1994. Restatement third of property servitude, section 3.1 of 2000. States presumption that in a servitude is valid unless it is illegal, unconstitutional, or violates public policy by unreasonably burdening a fundamental right or imposing an unreasonable restraint on alienation. The burden or harm is disproportionate to the benefit produced. It's a deferential standard. Some jurisdictions allow as an applied challenge. Loser pays the court costs. Association declaratory bylaws provide for recoupment of legal fees to defend bylaws from challenging non-conforming owner. In business judgment rule, courts defer to decisions of governing association and boards made honestly and in good faith. That's it for real covenants and equitable servitudes. When we come back together, we're going to discuss zoning. And conforming, non-conforming, uses, variances, special exceptions, and spot zoning, zoning amendments. reverse spot zoning. And that's actually going to be it. I then attached, Euclidean zoning is one of the first topics within zoning. I attached someone else's outline to my outline on the area of zoning. And then we went actually into chapter 13, eminent domain and the problem of implicit takings. And that's where I attached my constitutional law outline into this outline.
You want to grab your plate?
Mm-hmm. And so that'll go into the takings clause, regulatory takings, all types of takings. And explicit, implicit exactions. It goes into all the elements of a taking. And a lot of cases on it that we covered in constitutional law. So that's all we really have left is zoning, taking eminent domain.